Ms. Graham.
Thank you. Before lunch, I was asking you about the first meeting with the family, which took place on the 7th of February 2017, or around about that time, and I'd asked why you'd come into post as Lord Advocate on the 1st of June 2016 and why the first meeting took until the February. Now, I think before lunch you said you couldn't quite recall. Can I ask you to look again at something we looked at yesterday?
Of course.
Which was Frank Mulholland's inquiry statement, SBPI 00476. And I'm interested in paragraph 124 of this. And it's a short paragraph. It says, I spoke to James Wolffe by telephone and reiterated the importance of this inquiry, and this is a reference to the inquiry into the death of Mr. Bio, including the need to maintain good and regular liaison with the family. And we spoke about this yesterday, but do you remember now that conversation with Frank Mulholland, where the liaison with the family was discussed?
I've no recollection of it. I say I've no reason to doubt it. I mean, I suspect this was a call in the context of my appointment, and you know, it would be relatively brief, which is not to trivialise it at all.
Did you, in that period between the 1st of June 2016 and the beginning of February 2017, did you personally take any proactive steps or ask your Crown Office staff to organise a meeting with the family of Mr. Bio?
Well, I don't recall. It's fair to say it's now quite hard to, as it were, reconstruct the sort of taking up office, the induction into the range of responsibilities, issues, the immediate flow of work, and so on that arose. So, you know, I think the answer is no, I didn't, and I probably assumed that, you know, as I was getting my feet under the desk, dealing with that flow of work, seeing the sort of issues being brought to my attention, that you know, the system would you know, deal with that appropriately. I mean, I see in the previous paragraph my predecessor's observation that a full briefing would be carried out, as with the appointment of all new law officers, and certainly I was going through a series of briefings on a wide range of issues during that initial period, and I can't remember whether this, you know, whether this case specifically featured or not. We've seen the documentary record, but as I say in my statement, there may well have been oral discussion, which I simply can't remember.
And in terms of the Article 2 obligations on the Crown, in relation to the next of kin and the family of Mr. Bio, do you have any recollection now of how those obligations were being met in relation to the family during that period from you taking up office on the 1st of June 2016 up to that moment where you had your first meeting with them?
Other than that, I've seen some information about a meeting between. I think it's a meeting between Miss Miller and Mr. Anwar.
So you understood there was a meeting between the two of them that was...
Yes, I think there was an exchange of correspondence between Mr. Anwar and myself, which, you know, that's sort of in a sense entirely to be expected, part of which was, you know, to there should be a meeting. And then I think the sequence is that there was then a discussion between Ms. Miller and Mr. Anwar about the suitable timing of a meeting. And I would have been, you know, open to being advised about when was a good point for me personally to be to have that introductory meeting.
Thank you. I'd like to move on to ask you some specific questions about evidence that we've heard in the inquiry. It will not come up on the screen. We don't have that capacity, but you, to some extent, have dealt with issues about this in relation to, with regard to your inquiry statement. So I will, at the end, put up paragraph 114 of your inquiry statement, which deals with the two meetings that we'll be addressing. And I'll have that brought on the screen shortly. But the first evidence I'd like to ask you about relates to evidence we've heard from Caddy Johnson, who is Mr. Bio's sister. Yeah. And she gave evidence to the inquiry on the 31st of January 2023, day 34 of the inquiry. And she was asked some questions by myself regarding the meetings that she'd had with you. And she said, when we met the other Lord Advocate, that's a reference to you, we felt like he was not interested at all. He didn't give us much information. We had to hear things from the media, you know, so we didn't feel any engagement with him. Yes, I think if we had carried on in the same manner as we were carrying on with Frank, that's a reference to Frank Mulholland, we would have had a different perspective of him. So the difference was very much the amount of information you were receiving. And her answer was, and the lack of engagement he had with us as well. And I asked her, and when you say the lack of engagement, is that fewer meetings or fewer points of contact? And she answered, well, apart from the meetings with Frank, whatever he was going to do or wherever he was going to do his investigation, he was keeping us informed. And you know, we will have a discussion about it, and he will listen to our concerns and follow that up. But we didn't have that with the other Lord Advocate. That's yourself. Do you feel that's a fair reflection of the difference of approach between you and the now Lord Mulholland?
I mean, I can't speak directly to the detail of the engagement that he had with them. I mean, certainly reflecting back on it, that's intelligible to me, and I very much regret that that's the view that Ms. Johnson formed. It's fair to say that first meeting, in the terms in which I understood that the purpose of that meeting, I felt that had been a good meeting, as far as I can now remember. I certainly don't remember a feeling that it had gone badly in any particular way. Looking back, as we discussed this at the beginning of my evidence yesterday, there again one could see it as a missed opportunity to have been taken a more sort of strategic, long-term view. At the time, the purpose, as I saw it, was to introduce me to the family against the background when they had met my predecessor. As I understood it, for me to give them my own commitment to a thorough investigation. The subsequent letter from Mr. Anwar suggested that commitment had been received and welcomed. Again, with the benefit of, it's fair to say, much work and engagement at a later stage that I had with victims of crime, and reflecting back, I suspect I could be much more proactive in terms of trying to understand what the family would like to have by way of engagement, what would be helpful to them, and then to consider how best that could be afforded and accommodated. It's also fair to say, I suspect at that stage, even at that stage, I didn't anticipate that things would take quite as long as they did. And if things had come to a conclusion more quickly, then what with hindsight we could certainly see as a long gap wouldn't be there. I would have been entirely open to further meetings had those been requested, but I can well see that I could have been more proactive in terms of myself finding out what would be useful and helpful to the family, advised by their solicitor, of course.
Thank you. We also heard from Caddy in relation to the final meeting with you. We've heard that this was on the 3rd of October. Excuse me. And the evidence that Caddy Johnson gave to the inquiry was, she was asked, can you tell the chair what the impact was for you and your family when you heard about the non-prosecutorial through the media? And she talked about there being a knock on the door, so a journalist had to approach them to tell them. Obviously, this is her response. Obviously, we were upset because the Lord Advocate had promised to engage us, but again, that wasn't the case, so we felt betrayed there as well. I asked her, do you remember who the Lord Advocate was at this moment? And she said it was you. And we then went on to the subsequent meeting, and she said, yes, we had a meeting with him, and we raised that concern with him, and he said he will look into it to find out how that happened, because he had promised that he would let us know first before anything else. But I don't know if that was followed up. And I asked her, what explanation were you ever given as to why the media had that information before the family? And she answered, he said he doesn't know how, but he will investigate it. But I don't know what the outcome is with that. He will investigate how the media got to us before him, And what did you hear about the outcome of that investigation? I haven't heard anything about that. And I said, have you ever been given an explanation? And she said, no. We may hear from Addy at some point in the future, and he points out that you've never been given a written or an oral apology from the Crown about the fact that information went to the media before it went to you. And she said, that's right, yes. And she said that was also her position. And she explained that it had been very hurtful to hear from the media. Everyone else is hearing information other than us who are really affected. Now, I think if we can have your paragraph 114 on the screen, and from your inquiry statement, you do specifically address this meeting. Here we are. I recall meeting Ms. Johnson in October 2018, and I believe that she was also present at the February 2017 meeting. The purpose of the 2017 meeting was to introduce me to the family and to allow me to give them my own commitment to a thorough investigation, rather than to go into detail about the case. I very much regret if that left the family with an unfavourable impression. I entirely accept that the fact that the decision was reported in the media before I met the family in October 2018 was upsetting and distressing. I was personally horrified by it. Would you wish to elaborate on that?
Yeah, I mean, it was plainly going to be devastating for the family to see this headline. They were entitled to hear what would be, I could anticipate would be unwelcome news from myself and from the prosecutors who'd been working on the case. And that was the intention. And it's fair to say this report in the press clearly, was clearly going to be upsetting for them, and make that conveying that new information to them all the more difficult.
In relation to the aspect of evidence that we've heard that they never heard about the outcome of the investigation into how the information was leaked, do you remember what was done in relation to that investigation?
Well, there was internal work with it, and I've covered this in my statement. Lindsay Miller advised me what the Crown was intending to do. Mr. Logue later came and gave me, in effect, a report on that. Gave advice that what was possible and proportionate had been done, and I accepted that advice. I understood that Mr. Logue was going to convey information to Mr. Anwar. I have to confess, I don't, I haven't checked whether that was done or not, and I probably don't have the information available to be able to check that.
Right. But it was your understanding that the family would be given an explanation, such as it was.
Yes, I mean, which was we haven't found anything, and we've undertaken the what Mr. Logue advised me was the appropriate investigation in the circumstances, and I know there's a set of issues about that. But certainly I'm pretty sure in the documents I saw, Mr. Logue indicated that he would be advising Mr. Anwar, and I would not have any reason to think that wasn't done.
Thank you. And looking back at those meetings that you had with the family, you've obviously made comments in your statement, which we've looked at. But looking back and reflecting on how those meetings were handled, do you have any further thoughts you'd wish to share with the Chair about how this could have been handled better?
Well, as I say, I've had the benefit of meetings with Mr. Bayou's family, and then as I went on my incumbency, meeting with victims of crime more generally, not in the context of ongoing cases, but in the context of work being done across the system in relation to victims. And it's fair to say, an appreciation of the desirability of institutions being sensitive to the needs and wants of victims in terms of engagement with the system. Now, there are obviously institutional constraints and and also practical constraints of various sorts that apply. But I think that starting point of being, starting with seeking to ascertain from victims themselves what would be of value and benefit to them, and then thinking about how that can be met, and if it can't be met, to be able to explain that. Is something I've become, became appreciative of and came to understand. And I came to also appreciate across the, as it were, the system as a whole, just how challenging the criminal justice system can be and is for many victims of crime, and the need to try and work in different ways across the system to try and address those issues so that victims have confidence in the system. and it's one of the deep regrets I have about, reflecting back on this case, that Mr. Byers' family were left with a lack of confidence in the Crown and what the Crown had been doing, and a disappointment personally in the extent to which I contributed to that lack of confidence.
Thank you. So can I say, to sum up, that now, with the benefit of further experience and on reflection, you would begin by identifying what the family needed?
Yes.
And then see how that could be accommodated within the practical and institutional constraints within your role as Lord Advocate?
Absolutely. And I mean, the other feature of it, which I think I reflected in the paragraphs that we discussed at the beginning of my evidence yesterday, at the end of my statement, is that I think it was really unfortunate, again, looking back with 2020 hindsight, really unfortunate that in a sense, that I approached that meeting in the context of the purpose of it being simply, as I understood it, to introduce myself, to give a high-level commitment, and not to have thought forward to issues of a future process of engagement, the need to communicate and introduce the way that the Crown investigation was proceeding and would proceed, because I think one of the challenges, as I've reflected back on this, was a process in which, as I've explained, and for reasons that are were entirely normal, in terms I relied on a very experienced team who were undertaking the investigation and doing the work, and a very experienced Crown Counsel. And my own role was only ever going to be one at a sort of supervisory level, accepting that there may have been missed opportunities in terms of asking questions at particular points. And I think one of the I think I pointed in my statement to an exchange of emails where APCC wasn't available, but the decision was made that she didn't need to be at the meeting. I don't think it was a view that it wasn't appropriate for her to be there. I think it was really unfortunate she wasn't, because that would have been an opportunity to introduce and explain the way that the Crown investigation would go forward, and to perhaps set up an appropriate liaison, and to think about family liaison across the range of those involved, with myself coming in at the appropriate points, because I think the reality of the role that I held was that my active engagement was always going to be constrained by the range of demands on the office.
And are those examples of the types of issues that could have been covered within the strategy, if there had been such a strategy that you've mentioned yesterday and today?
Yes, one could have thought, as I say, thought, and again, I suspect at that very early stage, did I think it would take as long as it did? I think time has a deeply corrosive impact on those affected by the criminal justice system, and that's of course accused persons as well as victims of crime. And I became, in the course of my time, deeply concerned about, engaged with that corrosive impact that time and the passage of time can have on people. It didn't help that things took as long as they did, and as things were taking the time that they did, then again, reflecting back, one can't help but think it would have been a good idea to have been more proactive in terms of thinking about how to engage, through Mr. Anwar, of course, because he's representing the family with them.
Thank you.
I don't know if that's helpful.
No, thank you very much. I'd like to move on and ask you about some evidence that we heard in the inquiry from Colette Bell, who was Mr. Bio's partner and the mother of one of his children. She gave evidence to the inquiry on day 40 on the 9th of February last year, and she spoke about a meeting with yourself. She said, "But I remember in particular that meeting, and I think it was the newer Lord Advocate," which again was you, "and he had said something like, and this is in quotation marks, he's done it to himself. If he was responding to the arrest, he wouldn't have sustained his injuries." Or I'm sure he used words like that. Again, in quotations, "If he wasn't flailing around or fighting against it, then this wouldn't have happened." And I remember thinking, are you kidding me on? There's like 9 officers or 6 officers on top of him. How do you want him to react? And I just remember thinking, you're not having any more of my time if that's your opinion. And I certainly don't think that you're going to be doing anything in our best interests to help us. And then I think at paragraph 116 of your inquiry statement, you address the issue of whether a member of the family had become angry. And you'll see line 2, "I regret that I cannot specifically recall now if she was present. I have no memory of any member of Mr. Bio's family becoming angry at that meeting. Mr. Anwar's letter following the meeting suggested that Mr. Bio's family had appreciated my commitment to a thorough investigation and does not indicate that there was at that stage unhappiness or concern about anything which had been said by me or by anyone else. I would never suggest that Mr. Bio brought it on himself or otherwise use language to that effect." And I'd like to again ask you if you would like to comment on this suggestion that you said he's done it to himself. If he was responding to the arrest, he wouldn't have sustained his injuries. Do you remember saying anything along those lines at that meeting?
I mean, it's fair to say I've got very little specific recollection of that meeting. I mean, I picture in my mind of it, but I don't remember what was discussed. It's fair to say it's not language I would use. It's not a sentiment I would express. I think if I had done, it would have stuck in people's mind, in the minds of everyone who was there. And I certainly have no memory of any member of Mr. Bio's family becoming angry or upset at that meeting.
And insofar as she said, if he wasn't flailing around or fighting against it, then this wouldn't have happened. Do you remember saying anything like that?
I think it's unthinkable, and at that stage of the investigation, we're at a point where the report has been received, the Crown is engaged in an investigation of what happened, and if I look at the briefing that I received, I think it's a fair comment from another comment that I've seen that at that stage my my knowledge of the case was at a fairly sort of high level. There was an ongoing investigation which was to find out what had happened. I think it highly unlikely that I would have embarked on any sort of comment, leaving aside whether it's likely I would make that comment. I think in any comment about that would sort of prejudge where the investigation would come to.
Can you think of perhaps anything that could have been mistaken for a comment with those sentiments that you may have uttered?
I think the difficulty is I've got no specific recollection of what was said at the meeting. I can say what I think it's likely and what's unlikely. And I can say I don't remember, as it were, a difficult exchange at that meeting.
Thank you. Could you give me a moment, please?
Yes, of course.
Thank you very much. I have no further questions.
Thank you.
Thank you.
Sorry. Rule 9 application. Ms. Mitchell. Mr. Wolffe, would you mind withdrawing to the
Of
witness
course.
room while I hear a submission? Just give me a moment, Ms. Mitchell, till I find the live transcript again. Yes, thank you.
Thank you. The first issue I would like to explore is the question of complying with Article 2 and Article 14 in relation to having an effective, thorough investigation. In evidence, it was stated by Mr. Wolffe that the starting point, and I use that as a quote, the starting point for that is a skilled and experienced team who undertake that investigation. We heard from Mr. Wolffe in evidence that key performance indicators were unlikely to have addressed Article 2 and Article 14. So it's to ascertain if there was anything else done in respect of ascertaining whether or not the Crown was complying with Articles 2 and Article 14. In particular, was there any process of review? My learned friend asked whether or not there were any practices or procedures or protocols in relation to assessing whether or not Article 2 and 14 had been complied with, but was there any process of review? And if the reason that I asked that question is, would the trigger for an assessment at Crown Office at that time as to whether or not Article 2 or Article 14 been complied with only triggered by a complaint by a family? The second issue is in relation to a tension between the Lord Advocate Mulholland in respect of the handover and Mr. Wolffe. At Lord Mulholland's statement SBPI 00467, you will recall from a learned friend speaking to Mr. Wolffe that he says that he spoke to Mr. Wolffe by telephone, and the phrase is, and reiterated the importance of this inquiry, including the need to maintain good and regular liaison with the family. Now, the reason why he says reiterated is in the paragraph before, at paragraph 123, under the heading Handover of Investigation into Sheikh Obayo's death to Mr. Wolffe KC, Lord Mulholland states, as with the appointment with all new law officers, a full briefing would be carried out by Crown Office officials and SGLD, Scottish Government Legal Department, senior lawyers. So it's to ask, was there such a briefing by Crown Office officials in relation to this case? And was there such a briefing by Scottish Government Legal Department? If Mr. Wolffe clearly doesn't recall the telephone call, but were those things in place? And it seems that given the evidence on this, where he says that he thinks a formal handover would have been a good idea, it's clear that Mr. Wolffe believes that such a formal handover procedure is something which is actually in place, if one can call it that, to have briefings from those two groups of people. The third issue which I would like to raise is in relation to the decision taken by Mr. Wolffe and his explanation for not handing documents over to the family. And I think we've heard, first of all, in evidence that he wasn't convinced that Article 2 required disclosure, and he said he wasn't convinced it was correct in the context of criminal investigation, at least where there was any risk of prejudicing future criminal proceedings. And what I would like to put to him is Lord Mulholland's statement, SBPI 00476. And what Lord Mulholland says in relation to the disclosure of reports at paragraph 97 is, I cannot remember it, but if I did give an undertaking for disclosure of reports, then that would be fine. There is no reason not to disclose the reports. The case would go to a criminal prosecution or at least an FAI. They would receive disclosure of these reports in the course of those proceedings. This would include the PERT reports and the expert reports. This is not an exceptional undertaking. So it's to ask if he might reflect upon that and explain his view on the matter. And perhaps in particular with the view that any disclosure of these reports might impact upon the family of Sheikh Obayo if they were witnesses, given the fact that any witness evidence they were likely to give would be unrelated to any of the types of evidence that was contained in these reports. The next issue, number 4, is made with reference to COPFS 01353A, which I think has been made available, and that's a letter from Mr. Wolffe to Mr. Anwar in respect of his explanation that no more reports would be provided to Mr. Anwar other than the ones that he had been told that he was going to get. And the reason I want to take him to that document is because the document indicates that Mr. Anwar would get these reports, and in due course and when it was the appropriate time would be disclosed to him. And what I'm wanting to find out is, did he ever sanction those reports to be made available? If not, why not? And ought these to have been disclosed in advance to the family of the VRR procedure? Number 5, in the course of giving evidence, Mr. Wolffe talked about the structural independence that was required between investigators and those being investigated. And I would like to take him to a document, COPFS 02214, where it is stated in a meeting that he appears to have attended that the line of inquiry on restraint communicated by the PERC to the police caused Police Service of Scotland to express disquiet. And I would like to ask him whether or not did the fact that PERC was communicating in advance this line of inquiry to the police cause him concern. I should say these documents were disclosed after the Rule 9s, my Lord, just to be clear on that. They were disclosed, I think, Thursday and Friday of last week. Number 6, again, from disclosure, it appears on the 21st of September 2018, the Crown knew that the newspapers were intending on publishing a report that a decision not to prosecute had been taken. And presumably the Lord Advocate was aware of that or had been made aware of it. So I suppose properly that would be the first question I want to ask him. But secondly, what I would like to ask was there any consideration given in those circumstances to advising the family before the matter came out in the newspapers, either to the fact that there was newspaper reports on this or to give the decision, rather than the family finding out via the newspapers? The 7th issue is to explore when the Crown had considered Article 2 and Article 14, the former Lord Advocate, Mr Wolffe, said that he was acutely conscious that there were other considerations in respect of Article 2 and Article 14 than criminality. What I would like to know was, at the end of the Crown inquiries, was consideration given to reporting to the police in respect of any disciplinary matters? And at the end of the Crown inquiries, was consideration given to the reporting to health and safety in relation to any issues arising falling short of prosecution? Number 8, as the inquiry has heard, there was data held in respect of Mr Anwar that caused Perk disquiet, and investigations were made in that regard and reported back to the Crown Office. Once the Crown Office were in receipt of that information, was there any consideration given to informing Mr Anwar of that breach of data compliance? And finally, and touching upon what my learned friend's last questions to Mr Wolffe were, Mr Wolffe has clearly not a strong recollection of what happened with the family in meetings which he had with him, but it's to put to him whether or not at the meeting which was discussed with my learned friend, or perhaps a subsequent meeting, whether or not he remembers using the term "like a toddler" in respect of Mr Bio, and whether or not he remembers that having an effect on the family. Those are my questions.
Thank you. Well, we'll take the 15-minute break now, and we'll sit as soon after that as I can when I'm ready. Well, I'm going to allow Ms Mitchell to examine Mr Wolffe on the following issues. Issue number 6, whether the Crown could have advised the family once the Crown became aware that the prosecutorial decision was going to be published in the press. Number 7, whether consideration was given at the end of the Crown investigation to disclosing for the purposes of disciplinary proceedings and health and safety. And number 8, in relation to the data held on Mr Anwar. As to issue number 5, which raises certain concerns on the part of Police Scotland, I consider that this requires further exploration by the inquiry, so that will be developed, and it should not be explored today. As to the remaining issues, number 1, 2, 3, 4, and 9, I do not consider that I would be assisted by further examination of these issues with this witness. So I shall allow Ms Mitchell to examine on issues number 6, 7, and 8. Can we have the witness back, please? Mr Wolffe, Ms Mitchell, who's Senior Counsel for the families of Sheku Bayo, has some questions.
Thank you.
Ms Mitchell.
Thank you. We understand from the evidence that's already been heard that the Crown were contacted by the press in advance to explain that they were going to run a story indicating what the prosecutorial decision was. I take it that you were aware of that at the time when that was intimated and before the actual story came out in the papers?
I was made aware of it in looking at the documents that I was able to see before preparing my statement. There was a minute from someone in Crown Office Comms to me, basically seeking approval of a line which I suspect had already been approved by I would guess Lindsay Miller, but that's guess on my
indeed.
part.
And I think that note might have been probably on or around the 21st of September. I think that's the around about the time. What I would like to ask you is, when you received that information, was any consideration given at that stage to the Crown proactively contacting the family to make them aware that this was going to be in the press, and or, for example, bringing forward the meeting in order that the family could have the meeting and the decision with you in advance of that time? And if it was considered and refused, or if it was considered and that was decided not to happen, why was that?
Yes, I don't remember any consideration that reached me, and you know, as you put that point to me, I can well see that would have been the right thing to do at that point. I can't say whether it was considered at any, you know, as it were, by others in the system. Certainly, when the story appeared, again, relying on the documentary record, there's an email from me to, I think, certainly to the Crown agent and possibly also to Miss Miller, saying a number of things. One of which was, can we, and it'll be in the documents, but I think I was inviting contact with Mr. Anwar to accelerate the meeting, if that was possible. And I can't now remember, I'm afraid, what then happened in terms of the timing of the meeting.
I think from what you've said then, although you weren't aware that anyone lower down the chain, as it were, considered that, would it be fair to say that you didn't consider that either?
I didn't consider it, and frankly, now you put it to me, I can well see that would have been a courteous thing to have done.
Moving on, in your evidence you explained, of course, that you were acutely conscious that there were other considerations in relation to Article 2 and Article 14 other than criminality. It wasn't simply an issue of criminality. And what I am wondering was, at the end of the Crown inquiries, was there any consideration given to reporting to the police issues in respect of disciplinary matters against police officers?
I was copied in, I was asked a question about some correspondence of Mr. McGowan's in relation to issues of discipline. I can't myself remember being involved in consideration of intimating any disciplinary matters. I suppose those issues, would those issues need to await the VRR is one of the things that's in my mind. The Crown investigation, the potential for criminal proceedings is not exhausted until the VRR has been completed. Although I stepped back from the VRR process, that itself took some time and was done with, as my impression was, with some care.
Can I ask if that's a consideration you're thinking about now, as opposed to what you knew or what you considered then?
It's more that at the point where the decision in October, or the meeting in October 2018, that that initial decision not to prosecute, I don't recall there being any consideration given at that point that I was party to reporting any misconduct issues. I suppose what I'm reflecting now, as you ask me, is that it probably wouldn't have been appropriate to think of that. If it hadn't been appropriate earlier, it wouldn't be appropriate until the end of the VRR process. And I'm afraid I have no recollection of what happened thereafter.
Thank you. And can I ask you then whether or not at the end of the Crown inquiries was any consideration given to reporting to Health and Safety Executive in relation to any issues falling short of criminality?
I'm not aware of that.
Would you have expected to have been made aware of that if that was something that was going to happen?
I'm not sure is the answer, and on both of those, I'm not sure whether that's something that those are decisions that would be made by Crown Counsel or by senior staff. I suspect, given the particular profile of this case, and given that any reference to Health and Safety Executive would presumably be in relation to Police Scotland, I think it probably been brought to my attention.
Because I'm reflecting in that on your view that there were other considerations under Article 2 and Article 14, and I'm just wondering, you being the person that lands with at the end of the day, whether or not you knew of that, but the answer appears no.
No, I mean the key thing for me from the outset, and well, my recollection is relatively limited. I think, clear in my own mind that from the outset I was acutely conscious of that Article 2 required a thorough investigation of the circumstances of Mr. Bayou's death. I mean, this was not a case that called for a mandatory fatal accident inquiry, but I certainly took the view that it felt to be treated as if it did, for Article 2 reasons. We've seen the minute, the initial question was whether criminal proceedings should be brought, and that issue was exhausted. I always envisaged that certainly if there were no criminal proceedings, that there would need to be a process of inquiry, and as things moved on, I came to appreciate that there was going to be an inquiry, should be an inquiry, regardless of whether there was criminal proceedings. The shape of that inquiry, I remained, in a sense, open-minded about until quite late in the day, and then ultimately took the view that a fatal accident inquiry couldn't adequately deal with the range of issues that fell to be addressed, and advised the government, recommended to the government that they should set up this inquiry. But I entirely take your point. There are other processes which are all part of the state's response, which, if one is looking holistically at Article 2 and the compliance of the United Kingdom as the contracting state with its Article 2 obligations, all of those processes and potential processes are part of the system, which responds to Mr. Bayou's death.
Indeed, and perhaps you can see that's why I'm asking
Indeed.
whether or not consideration was given to reporting to the police or disciplinary matters or health and safety. Moving on in respect of the next matter, at some point in time, PERC became aware that there was certain data held on Mr. Anwar that was that ought not to have been held at all. Really, I was going to say in the way, but at all. And presumably, at some point, you were also made aware of this situation. Mr. Anwar had written, I think, both to the Crown and to PERC, asking them to investigate these matters. When you became aware of the information being held on Mr. Anwar, was consideration given to by the Crown to advise him of the fact that that information was held and maybe in breach of the guidelines?
I think, if I recall the sequence correctly, Mr. Anwar had raised a question of whether police had been accessing inappropriately records of particular individuals.
Indeed.
I can't remember whether he'd included himself in that list, and the PERC then investigated that, and Mr. McGowan's minute, I mean, it's fair to say I think I was probably made aware of this when the PERC report came in, but certainly Mr. McGowan's minute that we've looked at earlier in my evidence addressed this very specifically the issue of the holding of intelligence in relation to Mr. Anwar. It's fair to say, perhaps because of my professional background, I was rather very exercised by the idea that the police were collecting intelligence on a criminal defence lawyer, and if that was the position, as a former dean of faculty, I did not view this with equanimity. I had a discussion with the Crown agent at the time, and as I recall it, I mean, I certainly recall having a discussion with him about it. I may not have the sequence exactly right, but came to appreciate through advice that one has to, there are circumstances in which intelligence may appropriately be gathered in relation to lawyers, and therefore it's obviously a highly sensitive question. I should say I'm not suggesting that was appropriate in relation to Mr. Anwar.
Indeed.
And I think that was the outcome of the inquiry. But there are circumstances where it is appropriate. Inevitably, the gathering of intelligence itself is something that requires to be handled with some care, and disclosure of that needs to be it needs to be properly investigated, looked at by those whose responsibility it is to look at these things, and so that the judgment can be made. I was advised that the right course, if I remember correctly, was to ask the Information Commissioner to examine the question, and that it would be for Police Scotland as the data controller to fulfil their obligations. And I think there may have been a question at some point about the Crown raising the issue directly with the Chief Constable. I'm not sure just precisely what happened there. But anyway, the advice I had from those who were experienced in thinking about these things was that was the proper, correct process to go through, and that to proactively raise the issue with Mr. Anwar before those authorities had done their work wouldn't be appropriate.
And what about after the authorities had done their work and responded to that and made you aware of the final outcome, i.e. that proceedings weren't going to be taken, but yet you still had the information this breach had occurred? Did it occur to you, or did you have any discussions with anyone in the Crown Office whether or not Mr. Anwar should have been made aware of the situation that had occurred, given, after all, it was his data?
Yes. I can't remember, frankly, I'm afraid I can't remember whether there was consideration given to it or discussion about it. I'm not sure if the documents help. I do remember at some point, but whether it was then or at a much earlier stage, the point being made that it's the data controller has responsibilities in terms of communication. That wouldn't necessarily absolve the Crown from an appropriate communication, but it, as I've said, it was something that caused me concern. It was clearly highly sensitive. It needed to be investigated in the right way. I was given advice about what the appropriate course was. I can't remember what then happened in terms of thinking about communicating it.
Those are my questions, my Lord.
Thank you. Well, Mr. Wolffe, that concludes your evidence. Thank you very much for coming to give evidence to the inquiry. I'm very grateful for your time. The inquiry is about to adjourn for the day, and you'll then be free to go.
Thank you.
So we'll adjourn until 10 o'clock tomorrow morning.